Good morning, and thank you to the organizers for inviting me to present this paper at the conference. Thank you. I'm going to be talking about procedural fairness in arbitration. Having looked at the various aspects of procedure both in the legal sector and now in arbitration, it is timely that this particular topic needs some attention. The flow of my paper will be as follows. I'll have a brief introduction and an overview, and a slight look at the Arbitration Act of 2005 and how it has picked up the impact and the need and necessity for us to have procedural regulations. And I'll end up with a case study, CBP and CBS, a Singapore case, and finally, my conclusion. As an introduction, we'll find that procedural due process requires all legal proceedings to be fair, and every party has to be given a chance to be heard. This will apply to legal proceedings as well as to non-legal proceedings such as arbitration. But while due process is important within the process of international arbitration, how far can we allow the procedural fairness that happens in legal proceedings to be stretched in arbitration proceedings? Could it be that procedural fairness, i.e., a right to be heard, might impair the efficiency of arbitration as an alternative to litigation? Are we being fair in ensuring that this procedural fairness has to be applied into arbitration proceedings? Can the equal treatment of parties and procedural regulations, for example, like parties have to be notified and all parties given the right to be heard, be enforced as strictly as judicial proceedings, or can it be tempered? And if so, to what extent? Can it happen at the expense of procedural efficiency? Not forgetting the essence of arbitration is to resolve a dispute as soon as possibly able. These are significant questions that will be examined in this paper. When we talk about a brief overview about arbitration, I believe all of us here know that arbitration is a process by which parties consent to have a dispute between them referred to a third party selected by the parties, and if they don't agree, then selected by an institution. For example, in Kuala Lumpur, it is the Asian International Arbitration Association. Then you find that, do we then stop there? What if the parties still don't agree? Then we go on to the courts. So, the fundamental feature of arbitration is that the award is final and binding, although a particular award may be set aside in specific instances provided in the Arbitration Act. Arbitral awards are widely recognized and enforced, even internationally. It goes across borders. An arbitration award is recognized and enforced, and the entire jurisdiction of international arbitration is founded on the international enforceability of arbitral awards under the New York Convention on the Recognition and Enforcement of Foreign Awards 1958. As of December 2021, the convention has 169 state parties, which includes 166 of the 193 United Nations member states, plus the Cook Islands, the Holy See, and the State of Palestine. We adopted the New York Convention on the 5th November 1985. The Arbitration Act started, well, we had the first act in 1952 and then subsequently amended in 2005. So we have a new act, the Arbitration Act of 2005. The areas of focus, something that we need to consider here is the 2005 Act was enacted to cater to the increasing need for a modernized and global approach in arbitration law in Malaysia, and in consequence repealed the Arbitration Act of 1952 and the Convention on the Recognition and Enforcement of Foreign Arbitral Award Act 1985. It was enacted with the purpose to reform the law relating to domestic arbitration. It provided for international arbitration and the recognition and enforcement of awards and for related matters. The legal framework for international arbitration in Malaysia is governed by the 2005 Act. In addition, Order 69 of the Rules of Court 2012 sets out the procedural requirements as regards arbitration-related suits such as applications for the appointment of arbitrators and the enforcement of awards. The provisions of the 2005 Act were intended to be user-friendly for parties involved in arbitral disputes and to facilitate the resolution of international disputes by way of arbitration in Malaysia. For the international enforceability to happen, states indirectly delegate jurisdictional powers to arbitral tribunals through the recognition of the parties' agreement. Now, is that a good move? And that's what we have to see. How do we get there? It can be by way of domestic laws. Sometimes member states may allow for this by way of legislation, like it's done in Malaysia. On the other hand, we have parties' agreement. States indirectly delegate jurisdictional powers to arbitral tribunals through the recognition of the parties' agreement. Now, we then have the danger of delegation. When states indirectly delegate jurisdictional powers to arbitral tribunals through the recognition of the parties' agreement, this delegation of powers then comes as a type of trade-off in the form of minimum quality standards of procedural safeguards or due process. It is this delegation of authority of the arbitral tribunals that begs for judicial supervision to ensure that the procedural guidelines are enforced. Recognition and enforcement of arbitral awards in Malaysia is governed by Sections 38 and 39 of the 2005 Act. Under this, a party may apply to the High Court for an arbitral award to be recognized as binding and subsequently enforced as a judgment in Malaysia. So we need now to ensure that the party's application will then be judicially supervised to ensure that the procedural guidelines are followed. Due process. Now, let us look at this. This is mainly because by opting for arbitration, as I said in the earlier slide, parties to a dispute, by delegating, waive their constitutional rights to have their dispute heard by a national court. Therefore, as arbitration is a kind of substitute for court procedure, it's regulated, huge amounts are involved in arbitration. Therefore, some procedural standards need to be met to compensate for the loss of access to a court. It is this outsourcing the adjudicatory public functions of a sovereign state which calls for observance of the most essential rules of procedure, that is due process. In due process, we have what is called substantive due process and procedural due process. Substantive due process is where substantive law creates, defines, and regulates the rights. On the other hand, however, procedural due process will be the procedural law that governs the formal steps to be taken in enforcing substantive law. So we can't have one without the other. Thus, procedural due process is understood to set limits on the exercise of power by the state by requiring that it follows certain rules and procedures. Thus, having set the limits on the exercise of power by the state, how will this impact international commercial arbitration? And this is where we will be looking at this particular case. In CBS and CBP, a Singapore Court of Appeal decision, it was one of the rare occasions where the court had set aside an arbitration award. What the arbitrator had done was he did not allow a hearing for an oral witness evidence. And this was found to be breach of natural justice. Despite the challenging party refusing to submit any written witness statements. This is something known as the witness gating powers. The Court of Appeal found that on the facts, the arbitrator's rejection of the buyer's proposed oral witness evidence and the imposition of a condition to show that this had substantive value before even deciding whether to allow it at a hearing fell outside the range of what a reasonable and fair-minded tribunal might have done. And so this represented clearly a breach of natural justice. The next question then arises. Will the above case will now be an appeal mechanism for an arbitral award that is set aside due to an infringement of the rules of natural justice? It is right that an award may be set aside if there has been a breach of the rules of natural justice. But do note that in arbitration, there is really no clear avenue or path for the parties to challenge such procedural rulings. So, in the CBS case, what happened was the arbitrator had misinterpreted the SCMA rules and did not allow the respondent to call its witnesses. The respondent disagreed with the arbitrator's decision and refused to attend the hearing. But when the award was published, he sought to set it aside pursuant to Section 24B of the International Arbitration Act. He kept quiet and then he decided to set aside the award. So, the court felt it was time for a change. Let's have a look. The issue of completing an arbitration only to have the award set aside and then having to recommence proceedings could be avoided if parties had recourse to the courts, where a tribunal makes a procedural ruling which infringes the rules of natural justice. So this should be something like the competence principle. The arbitrator or the arbitration tribunal has the power to declare that, well, this was a procedural ruling and this infringed the rules of natural justice. While in the hearing itself, parties can bring that up. So where the tribunal's procedural ruling infringes the rules of natural justice, the court would not hesitate to set aside the award and the tribunal's procedural ruling. This is because while the tribunal is the master of its own procedure, it is still subject to the rules of natural justice. The case has quite an extensive explanation of this on paragraphs 62 and 67. So some of the safeguards that we can think about regarding this is perhaps to introduce an appellate mechanism for only procedural rulings which infringe the rules of natural justice. And implementing such a mechanism even before the award is rendered. Why we want to do this is we want to cut on time. The advantages, clearly, this saves time and costs as courts can prospectively decide on whether certain conduct is in breach of the rules of natural justice rather than to do so retrospectively. Second, this reduces the possibility of the award being set aside, enhancing the finality of the award. An arbitration award is supposed to be final and binding. Third, possible breaches of the rules of natural justice would be ventilated in the course of the proceedings, avoiding any duplicitous work at the setting aside stage. This would therefore ensure that the parties have their rights preserved, a right to be heard, and a right of reply without prolonging the time of the hearing unnecessarily. So, in conclusion, we want to prevent, all right, a kind of abuse of process because the availability of an appeal mechanism will actually sometimes lead to delays. Parties will start running to the courts. I mean, raising this during arbitration. So you don't want that. What do we want to do is we have to make sure that before the parties can avail themselves to before they can say that, oh, there has been a breach of natural justice, we need to have the powers given to the tribunal. The tribunal is the one because, number one, an arbitration award is final and binding. And number two, arbitration wants to minimize court interference. So, what should we do is the tribunal should have the discretion to continue with or stay the proceedings. Overall, resources should not be wasted whilst preserving the principle of minimal curial intervention by restricting such applications only to procedural rulings that infringe the rules of natural justice, especially since the same objections would have arisen if a party were now appearing in court trying to set aside the award under the existing laws that are in place. Thank you.